Everyone. Better? Oh, no. Ignore the beauty of participants. No? That we have done. No, but good. Let me just double check.
Good afternoon, everybody. We're about to start very shortly. Please have a seat, have some water. We're going to start in a couple of seconds. Excellent. I hope you can all hear me well. Great. Well, good afternoon, ladies and gentlemen. Thank you for joining this session focusing on Africa as a hub of ADR. We are here in Dubai for the Dubai Arbitration Week, and we're extremely excited to be part of this incredible week. And today, during this panel discussion, we are glad and honored to welcome the Honorable Chief Justice and President of the Supreme Court of Kenya, Lady Martha Koome, who is joining us online, and we're extremely grateful for her to be with us today during this session. We also have Mr. Mohammed Dahbashi, who is the Managing Partner of ADG Legal. We have also Mr. Kunal Vajani who is the Joint Managing Partner of Fox and Mandal. We thank these both firms to be our sponsors and knowledge partner for this event. We also welcome Ms. Zoe Giannopoulou from the European Institute of Conflict Resolution. She's the director of this organization. And we welcome Mr. Rahim Shamji, who is the founder and CEO of ODR International. And Rahim, may I invite you to start with your opening remarks?
Thank you very much, Dipna. Good evening, everyone in the room and online. In particular, warm welcome to our Honorable Justice in Nairobi, and to Kunal and Mohammed for joining us this afternoon, this evening. Zoe and I are very grateful on behalf of ADR International and the European Institute for Conflict Resolution to bring this subject of Africa as a hub of ADR to Dubai Arbitration Week. As someone who originates from Kenya, it has a very special place for me in my heart, and I have always been thinking about how do we bring this poignant question to all discussion, which is how do we make Africa this hub of ADR that has been spoken about for a long time, but maybe we are on the cusp of seeing some moves. For too long, Africa has been seen as a continent that looks to the West for guidance in this area and not necessarily developing its own institutions. But in the last few years, we have seen remarkable characters, including the Lady Chief Justice, who joined us today, who really has put dispute resolution on the map, and I'm looking forward to hearing from her today. I'm also delighted that Mr. Mohammed and Kunal will be sharing a lot of knowledge to help Africa from their own jurisdictions, the Middle East and India, about what challenges lie ahead. Today is also a very special day for ADR International, as we launched AOI Law, and that's the banner to my left over there. AOI Law is a new legal consultancy specializing in efficient and accelerated dispute resolution through arbitration and mediation, and we're based in Mauritius, Dubai, Paris, and London. And we will seek to work with other established law firms on the international dispute resolution landscape, but not as a neutral as we do at ADR International. But I want to thank all of you for coming here today, and for those of you watching on YouTube, I'm really looking forward to our discussions. Thank you, Dipna, and to the panel.
Thank you very much, Rahim. So we will start the session with our keynote speaker, the Honorable Chief Justice of Kenya. I will give a brief introduction and let you know more about her career. So Chief Justice Martha Koome assumed office on the 21st of May 2021 as the 15th Chief Justice of the Republic of Kenya and as the third President of the Supreme Court of Kenya. She's the first woman to hold the office of Chief Justice since the judiciary of Kenya was established more than a century ago. So that's a real achievement. Prior to her appointment, the Chief Justice served as a senior judge of appeal, and she joined the judiciary in 2003 as a High Court judge, where she served until 2011. Upon her admission to the role of advocate in 1987, the Chief Justice served as a legal practitioner for 15 years, carving out a niche in conveyancing, commercial law, civil litigation, criminal litigation, and family law. She has been actively engaged in multiple community service projects and promotion of children and family matters through volunteer and pro bono services. Chief Justice Koome milestones include being a council member of the Law Society of Kenya between 1994 and 1996. She was involved in the formation of the East African Law Society in 1995 and served as the inaugural treasurer. While at the East African Law Society, Chief Justice Koome participated in negotiations towards the enactment of the East African Community Treaty and institutions of this community, including the East African Court of Justice. In 1997, she was elected chairperson of the Federation of Women Lawyers Kenya chapter, the FIDA Kenya, and served in that position for 2 consecutive terms. While at FIDA, Chief Justice Koome championed for legal and constitutional reforms for gender equality. Chief Justice Koome is keen on making the Kenyan justice system people-centered and is placing particular emphasis on enhancing access to justice for the vulnerable and marginalized. She's celebrated as a revolutionary jurist who participated in the law review process, which gave rise to the Constitution of Kenya in 2010. In 2020, the United Nations recognized Chief Justice Koome as an eminent human and children's rights defender, following years of dedicated work in pursuit of the rights of women and children. Notably, she chaired the National Council of the Administration of Justice Committee that reviewed the Children's Act and established court user committees focused on child justice. In appreciation of a decades-long pioneering work on advocacy and advancement of the rights of children and the marginalized, she was voted runner-up for the United Nations Person of the Year in 2020. Chief Justice Koome holds a Bachelor of Laws degree from the University of Nairobi, a postgraduate diploma in law from the Kenya School of Law, and a Master of Law from the University of London. Lady Koome, we are absolutely thrilled, delighted, and an honor to have you with us, even remotely. So we can't wait to hear your keynote speech.
Thank you very much, Moderator, Madam Joey, for that very kind and generous introduction. A very good afternoon, good evening to very, very distinguished participants and also the facilitators of this wonderful conference. I'm most delighted to address the NDR ODR International Dispute Resolution Week, and I wish to thank the NDR ODR International for inviting me to address this very distinguished gathering. My profuse apologies, I could not make it to Dubai owing to emergent exigencies of duty here in Kenya. I could not join you in person, although we had tried to make the necessary preparations. I hope for better luck next year. I will be with you, inshallah. I commend NDR, ODR International for your commitment to enhancing ADR standards across the globe. Indeed, we are told the world now is a village, and particularly in Africa, through robust training programs that you have been engaging in. I am confident that the week's courses and events will enrich our participants' knowledge and in turn will drive very significant progress in dispute resolution all over the world. My topic this evening is on the theme Africa as a Hub of ADR. I have just completed a fellowship on ADR and all its facets, which was administered by the University of Pepperdine from the United States of America, where we were in class with 16 Chief Justices from Africa. And we were looking at all facets of ADR negotiations, mediations, alternative justice systems, pre-bargaining. And after a lot of interrogation of the topic, it was discovered that Africa is actually the repository of ADR, and colleagues there, especially the Chief Justice of Uganda, Honorable Mr. Justice Alphonse Owino, started saying it is not ADR, it is Africa alternative dispute resolution. So as we gather to reflect on ADR expanding role, it is essential to recognize that Africa holds a unique position in shaping the future of dispute resolution. This is not merely about adopting a global trend. It is about revitalizing a time-honored tradition and creating innovative frameworks that serve Africa's growing socio-economic landscape. Distinguished participants, Africa has a long-standing tradition of community-based dispute resolution mechanism that predate modern judicial systems, which was introduced during the colonial times. Long before formal courts existed, African societies employed dialogue, mediation, and consensus building to resolve conflicts within our communities. These indigenous practices emphasized social harmony and reconciliation as values that are absolutely central to ADR, including today. Modern ADR practices, therefore, do not represent a break from our heritage, but rather a continuation, a reawakening, and evolution of ADR adapted to meet the contemporary needs. In recent years, we have witnessed a remarkable shift towards ADR across Africa, which is driven by multiple facts. The first one is ADR offers a quicker, more cost-effective alternative to traditional litigation. That's a fact. Given that many African countries face substantial court backlog of cases and limited resources, ADR provides a critical pathway to timely justice, which is invaluable for those in need of swift resolutions. Secondly, ADR resonates with our cultural values, which prioritize reconciliation over retribution. African societies are inherently community-oriented, and ADR aligns with our emphasis on social cohesion, making it more accessible and acceptable to our people. This alignment reinforces ADR's legitimacy and appeal across diverse African societies. Finally, Africa's growing attraction as a destination for international investment underscores the need for dependable and a neutral dispute resolution mechanism. And ADR offers this amicable and efficient way to handle cross-border disputes, thereby fostering investor confidence and creating a conducive environment for business growth. Ladies and gentlemen, the institutionalization of ADR across Africa signals a deep commitment to integrating these mechanisms into the mainstream of our dispute resolution mechanisms. Several African countries have established dedicated ADR centers, such as our Nairobi Center for International Arbitration in Kenya, the Kigali International Arbitration Center in Rwanda, and the Lagos Court of Arbitration in Nigeria. These institutions provide essential infrastructure and resources, thereby positioning ADR as a credible alternative to litigation. Additionally, many African governments are incorporating ADR mechanisms into their national legal frameworks. Kenya's own National Alternative Dispute Resolution Policy, Sessional Paper Number 4 of 2024, offers a very comprehensive framework for promoting ADR. I must mention Article 159(2)(c) of the Kenyan Constitution, which explicitly endorses ADR, highlighting its importance within the legal landscape. And we all have a duty to promote ADR and alternative justice system. The Kenya Judiciary's blueprint, the social transformation through access to justice, also emphasizes ADR's role in enhancing access to justice. Together, these legal and policy frameworks underscore Kenya's commitment to making ADR an integral part of justice delivery. You will find similar commitment to the promotion of ADR in other jurisdictions across the continent. Africa's commitment to ADR extends to regional institutions as well. I wish also to mention the treaty establishing the East Africa Community, for instance, which has incorporated arbitration within the jurisdiction of the East Africa Court of Justice. And for me, this is critical for managing cross-border disputes. By providing a regionally recognized platform for arbitration, this reinforces the recognition of the importance of ADR beyond the domestic level. Turning to the future and opportunities for ADR in the continent, it cannot be overemphasized that technology is poised to play a transformative role in the future of ADR on the continent. The rise of digital ADR platforms that was spurred by COVID-19 pandemic has made it possible to conduct arbitration and mediation remotely, removing geographical barriers and significantly enhancing accessibility. Given Africa's unique technological landscape with very widespread mobile phone access, these advancements make ADR more inclusive and accessible to all. I must also mention the artificial intelligence, AI, which has immense potential in streamlining ADR processes. AI can assist in case management, data analysis, and even decision support, expediting the resolution process and reducing costs. Online dispute resolution, ODR, is rapidly gaining traction, further democratizing dispute resolution. Africa's technological adaptability provides a fertile ground for these innovations, allowing the continent to reflog traditional ADR limitations and deliver efficient and inclusive justice. Africa's evolving economic landscape is another key driver for ADR's growth, rising from foreign investment and the African Continental Free Trade Area, which create vast economic opportunities, but also increase the potential for commercial disputes. ADR offers an effective mechanism for resolving these conflicts, allowing businesses to continue operations without costly litigation. The flexibility and efficiency of ADR, the privacy, particularly appealing to foreign investors, align with AFTA's collaborative spirit, which promotes trade and economic integration across 54 countries in Africa. Bilateral and multilateral treaties further strengthen ADR's role in investment-related disputes. It is notable that there is an increased incorporation of arbitration clauses in trade disputes and treaties that countries in the continent enter into with foreign investors. Such bilateral investment treaties provide a clear framework for investor-state disputes, ensuring that such conflicts are resolved by impartial tribunals under internationally recognized rules. These frameworks provide both predictability and security, which are vital for a stable business environment. With the rise of environmental and social governance issues, ADR offers an ideal platform for managing complex disputes in these areas. ADR's emphasis on cooperation makes it particularly suited for addressing conflicts over environmental impact and corporate social responsibility and community rights. Through ADR, corporations can engage meaningfully with the stakeholders, including local communities, thereby maintaining their social license to operate while promoting sustainable development. Ladies and gentlemen, despite ADR's growth, public awareness and understanding of ADR mechanisms remain limited in many parts of Africa. And that is why ODR has a duty to do more, especially in Africa. Many individuals and communities are unfamiliar with ADR options, defaulting to litigation due to a lack of information or confidence in ADR mechanisms. Therefore, raising public awareness and educating citizens about ADR's advantages are crucial steps in making it a go-to solutions. There is also a shortage of skilled ADR practitioners across the continent. Effective ADR relies on trained mediators and arbitrators who can conduct proceedings fairly and efficiently. To address this gap, we must invest in professional development of ADR practitioners and ensure standardization of the practice of ADR. While there are strong ADR institutions in some African countries, infrastructure and capacity are limited in others. We are all not at the same level. Without sufficient institutional support, ADR processes may face challenges in enforcement, management, and overall effectiveness. African nations must therefore prioritize the development of robust ADR infrastructure, with facilities and resources capable of supporting ADR at all levels. Additionally, frameworks to ensure enforceability of ADR decisions are crucial for its credibility and effectiveness. In several African jurisdictions, ADR systems have yet to be fully integrated with the formal legal frameworks. The effectiveness of ADR is often constrained by a lack of clear rules governing how ADR outcomes are enforced or recognized by courts. For ADR to be a practical alternative, there must be legislative and procedural clarity that allows ADR decisions to be honored and enforced by the courts. Countries that have already embedded ADR within their constitutions and their laws, such as we have done in Kenya, provide a useful model for others to follow. To overcome the challenges that I have identified requires collaboration and partnerships, such as what is happening with ADR/ODR. Governments, the private sector, and training organizations such as ADR/ODR International must work together to build robust and efficient dispute resolution systems. In Kenya, collaboration is ongoing between the government, the judiciary, and the Nairobi Center for International Arbitration, the Chartered Institute for Arbitrators Kenya chapter, where I am honored to be the patron, and other stakeholders who have been instrumental in advancing ADR. Initiatives like training programs, advocacy for policy frameworks, and public awareness campaigns have all contributed to the growth and acceptance of ADR. In conclusion, Africa's potential as a hub for ADR is immense. As stakeholders, we must nurture a collaborative spirit, leveraging our resources and expertise to strengthen ADR systems across the continent. I urge you, therefore, to use the ADR/ODR International Dispute Resolution Week as a platform for forging partnerships, sharing insights, and coming up with strategies towards making ADR not just an alternative, but the preferred mode of dispute resolution in Africa and across the globe. Together, we can build a future where ADR becomes a pillar of access to justice, economic growth, and social harmony for Africa and the rest of the world. I thank you for listening.
Thank you, Honorable Chief Justice, for sharing your views and your opinion with us and for this excellent keynote speech. For the second part of this session, I will now be asking questions to our panelists, and I will invite the Honorable Chief Justice as well to join the discussion, especially if she has some additional points to make or any remarks to share with us. So I will start with my first question. That is for you, Mr. Mohammed. Thank you so much for being with us today. And as I said, Mr. Mohammed Dahbashi is the managing partner of ADG Legal. And we thank you so much for being here with us today and for sponsoring this event. And my first question is the following. Based on your own practice in Dubai and your wider presence in the Middle East, why do you think Africa should become an ADR hub? And how would it help the Middle East?
Thank you. Thank you for inviting me. And it's a pleasure to hear a wonderful speech by everyone here, and exceptionally also from her Honorable Justice. Interesting question, and I think with your question, you assume that I agree that Africa should become an ADR hub. And I might have not assumed before this, but after hearing the wonderful speech by Chief Justice Martha, I might have changed my mind. So thank you, Your Honor. But I think, Her Honor did a great job in explaining, what facilities and what Africa has been doing for ADR. So I don't need to go into details there. But it's important for us to take a step back, and maybe because I know we're quite limited on time, so I'd like to quickly take a step back on ADR in this region and in Africa. When I talk about this region, I talk about the Middle East. Now, doing business in the Middle East, we get exposed to a lot of work in Africa for various reasons, one of them being logistics, connectivity to Africa. We could be a small extension to Africa, to be honest. But what you realize when you do this is you realize that, as Her Honor mentioned, that the world is a village. And the Middle Easterns, they are villagers by nature. And when you do business in Africa, and Africa is a huge continent, as everyone knows. If you look into it geographically, it covers more than a third of the world. So Africa is huge. But something I realized in the majority of countries I did business with was the mentality was very similar to the Middle East. And where does that bring us to the way we look at transactions and disputes? And this goes back to our roots and I would say the roots of the Middle East, from civilization. And civilization generally came at around 1500 years ago when Islam was introduced to the Middle East, and that was kind of the source of education. And what happened there was, the Middle East was, basically villagers where they would sit in a tribe, and there would be tribal leaders, and the tribal leaders would be the mediators. And the way disputes were to be resolved were, two parties would go to the leader of the tribe and discuss the issue with him, and that leader would mediate. Why is that different to going to a court of justice? Because the court of justice could be strictly restricted to the laws that allow people rights, where a leader would mediate and understand different factors. And these factors could be commercial, emotional, reputational, family related. And he would look at the foundations of the laws that are available. And I think that is what the role of mediators and any role of a person sitting in the middle of an ADR process. So what happens is, so when I compare the Middle East to Africa, I see that the mentality is very similar. And I see that because of the size of Africa, and because of another part that Her Honor mentioned, the amount of investments and the amount of developments that are going into Africa today, it is important to look at Africa as a key and critical place for resolving and for ADR resolutions, and to use that and understand and develop that tool in Africa. So I would lead it by saying, I don't think Africa should be the hub for ADR, but I think it is critical to have a hub of ADR in Africa, because Africa in itself needs to serve itself, and it needs to serve it in the way people understand it there. You can't go to a very different country, a very different mentality, and try to resolve a dispute of that nature there. It has to come. I always believe that it has to come from within, from the nature of from the nature of the area, because that is how you understand the cultures, the people, and all the other factors around that dispute.
Thank you very much, Mr. Mohammed, for this answer and for pointing out that Africa should not become a general hub for ADR. But perhaps, Lady Koome, you would like to add something on what has just been shared by Mr. Mohammed?
Yes, thank you very much. It's just to absolutely agree with the submissions made by Mr. Mohammed, that NDR traditionally is was our way of life. We believed in restorative justice. We believed in fostering harmony. If you're in business, you do not want to break down that relationship by going to court, dragging each other to court to give evidence and wait for a judge who has even no idea about your culture, how you do things, make a judicial pronouncement. Then there is the process of following that judicial pronouncement, enforcement, which is being resistant, people going on appeal. So people always sat around the fire and discussed everything and resolved all the disputes. People were agents of their own destiny, and they had solutions because they know where the rain started beating them. In other words, they know where the problem started, and they very well know the solution. So what is being promoted as ADR is absolutely African way of life. What we have missed is in between the colonization, when we were colonized, and the common law was introduced to us, we lost our connection and we lost our identity. So we are retracing our steps to say, look, this foreign
Such an exciting moment. What's the next word's about?
The next season.
Sorry, we lost you.
Lady Cook, we just lost you for a couple of seconds.
Oh, sorry. Are you hearing me now?
Yes, we can. Thank you very much.
Oh, sorry. So I was saying Africa is the home of ADR, but we lost our sense of direction or identity during colonial period when a new legal system was introduced to us. And therefore, it had to replace everything African that we had, including ADR. So like in Kenya, I was mentioning we did justice needs survey to see the number of people who can access justice in the formal courts using the law. And we found it's a very negligible percentage, 20% actually. The rest resolve their disputes in their communities, with the chiefs, with the elders, in their religious organizations, in the mosque, in the churches. And we said then we cannot disconnect with such a huge percentage. So that is why in Kenya we have a very robust engagement right now with communities to revive alternative justice system by reviving those community elders to resolve disputes. We are training them on human rights imperatives and principles of fair hearing and inclusiveness, non-discrimination, so that they can do good agreements that, in their settlements, which we can adopt as a court and make it an order of the court. So Africa truly is the hub of ADR.
Thank you very much. Thank you. So I'll now move on to the second question. Mr. Kunal, the second question is for you. We thank you for being here with us today to start with. So as I said, Mr. Kunal is the joint managing partner of Fox and Mandal. And my question is the following. We all noticed the rapid rise of ADR mechanism in India, especially in the use of mediation and arbitration. And based on your experience and practice in India, what are the biggest challenges or even pitfalls in India that Africa should be aware of and try to avoid?
Thank you very much. Thank you very much, Your Ladyship, Honorable the Chief Justice. In fact, I will sort of agree and disagree with my brother Mohammed. My brother Mohammed said Africa is a region unto itself, and it's a zone which is self-recognized. But let me tell you, your friends in the Middle East, that is India, recognize this whole region as the MENA region. So we don't take Africa separate from the Middle East, and we always refer it to as MENA region. So that's point one. Two, what we've seen in India, and India today has had a codified arbitration law over the last century. The earlier round was in the 1923, 1940, and the 1996 Act. With over a century of a codified law, what we have learned in India is you can never make any jurisdiction a hub for ADR. ADR is an ecosystem. You can only make a good ecosystem because ADR is no longer an alternative. It is an additional method of resolving disputes. So alternative has been completely substituted for it to be an additional dispute resolution mechanism. We don't see it as an alternative. We see it as a support system to our own judiciary, and we see it as a support system globally for resolving disputes for all kinds of matters, be it cross-border, investment treaty, all sorts of disputes get resolved through the ADR mechanism. So it's no longer an alternative, but it's an additional method as we see, and therefore an ecosystem is very, very important. What every jurisdiction needs is to build up a big infrastructural as well as cultural ecosystem. Talking about the various jurisdictions, be it MENA region or India, culturally, we always resolve disputes with what Honorable the Chief Justice said, party autonomy. Parties decided how they wanted to culturally resolve the disputes, somewhere across the fire, or somewhere with somebody intervening within the jurisdiction, or what happened domestically, even in the colonial era, when India was colonized, the Panchayat Raj. We had panchayats, which were the village bodies, which would get together and sit and resolve disputes under a tree round the corner. So this has been the culture of all these jurisdictions. This is how we have resolved disputes. So party autonomy and recognition of party autonomy in every jurisdiction is very, very important. And I think that has been a big success story as far as India is concerned. A word of caution, and it's something which we have not been able to resolve in our jurisdiction, and at the cost of not being held up for contempt by your ladyship, is arbitration or mediation should not be seen as an after-retirement job for the judges, which is where India has fallen. And that has not made that whole system in India a cost-effective mechanism. So cost and time are both very quintessential when we look up to create an ecosystem for ADR. And what Africa needs to keep in mind whilst making this ecosystem is to make it very cost effective and time efficient. Cost effective, the only analysis that we've got in India as of now is that if you pick up institutions which have been pre-existing for years and recognize the institutional way of doing arbitrations and not ad hoc way of doing arbitrations, it becomes cost effective and largely even time efficient to a certain extent. Selection of arbitrators and training, which is very important, which is what ADR ODR does, is also very, very important as far as creating an ecosystem is concerned. In India, what we suffer, and that is what a second pitfall that I see, is we do not have either a dedicated pool of arbitrators or a dedicated pool of arbitration practitioners. So for the ecosystem to evolve, and with the hope that it becomes a hub, one needs to have qualified arbitrators and qualified arbitration or mediation practitioners. And that's a very, very important system to be developed, which is quality assurance in terms of training and continuous learning on modern systems, which is where ODR comes. And what your leadership mentioned about AI is absolutely true. And something I learned yesterday at the panel I was sitting, and it was a wonderful statement that I heard, that AI will not replace humans, but it will certainly replace humans who don't use AI.
My mantra.
Yeah,
So I think technology and the online way of resolving disputes was a big lesson that we learned through COVID. And each of these jurisdictions to build up a good ecosystem for this very clear, appropriate or additional dispute resolution mechanism, the online day would be a great result. Thank you very much.
Thank you very much, Mr. Kunal. Thank you very much. Your ladyship, is there anything you would like to add to what has just been shared with us?
Not at all. I'm just enjoying the wonderful presentations from India and just seeing how similar we are actually. There is, I mean, what brings us together is a lot more. There's so much commonality. And therefore, I think there's a lot of future for ADR, and I agree, or I'm quite impressed by the terminology. It is not the alternative, but there's the one that assists in resolving disputes quickly and being cost effective and all that. It's really wonderful. Thank you very much for allowing me to participate in this great gathering.
Thank you. So I will now ask my third question. It goes to you, Zoe. So I would like to ask you what would be, according to you, the infrastructure or even standards that Africa would need to adopt or improve to support its plan to become an ADR.
Well, thank you so much, and congratulations to all of you for the amazing, wise words, especially Chief Justice, and to both of you. I believe you mentioned the criteria that one need, and this is the quality training for mediators and arbitrators. I totally agree with the reform of the judicial system. We can see that, and we discussed this in police as well, because now we are trying to establish a robust ADR system. And if the judicial system is not involved, we cannot succeed. And this is the result after 10 years of trying to promote and to create this awareness that Chief Justice mentioned at the beginning. So I believe creating strong panels with strong mediators and arbitrators, experienced ones, is one key factor in establishing ADR.
Thank you very much. And do you think that there are similarities that you can find between the European, because your experience in the European market, similarities between the European market and the African market, and some other standards that are already thriving in Africa? There are some standards that we should import and try to improve within the African context.
Yes, thank you so much. To be honest, I'm really impressed, because while I was listening to all of you, I realized how many common concerns we have. And since I'm trying to, because we advise the British Ministry also on ADR, and in the European, in all the European countries now, we are trying to create a stage of mandatory mediation. And up to this month, 20 out of 27 countries in the EU have already adopted a mandatory session for mediation. This is a way of creating this awareness. So maybe this might help other jurisdictions as well to support the mediation system and the arbitration system. And I think mandatory mediation is very important.
Thank you very much. Lady Koome, is there anything you would like to add to what Zoe has just said?
Okay. Just to share an experience from the Kenyan judiciary, because my colleague from the European Union as mentioned, the move to make rules for mandatory mediation before you can maybe engage in the judicial process. What we have done in Kenya is to establish mediation as a parallel. We call it the court-annexed mediation. So when cases are filed in court, they are screened, and the judicial officer who is in charge of the screening and locating mediators. We have trained very many mediators. We have a curriculum, and we have a code of conduct that they sign to about their professionalism. So many people are opting for the court-annexed mediation, especially family matters. We have a lot of disputes involving families that touch on inheritance issues, or what I would call succession, if you like, and land disputes, neighbor against neighbor, or people who are selling to each other land and property. So they are opting for court-annexed mediation, and we are recording a lot of agreements. I think the success rate is about 80%, where we have settlement agreements, which the court now adopts. We have not reached the stage of mandatory, because we have a very robust constitution that spells out freedoms, and we have been fearing that we may be taken to court for forcing people to go for mandatory mediation when the court is also there. So we are watching carefully what is happening in the European Union, because that in the fullness of time, when people are used to mediation and negotiation and alternative justice and ADR, then it may just become a way of life, and therefore, before you come to court, first of all, you go through that forum. Thank you.
Thank you very much. So we started with Africa, with Lady Koome. We moved to the Middle East, expanded a bit to the MENA region for Kunal, and then we moved to India, we went to Europe. Now we're going to another European country which was bold enough to publicly leave the continent, the European continent. Rahim, my question goes to you. It's going to be my last one.
Feeling the Brexit pressure there.
No judgment at all. So, well, on top of working in the UK, you've been working a lot in Africa, Rahim, and you've been, dealing with so many African matters for quite some time now. What would be, according to you, the 2 top challenges and the 3 top advantages that Africa would have?
So the biggest challenge is when we think of Africa, we're talking about a continent full of great diversity. And I think one of our challenges for Africa in its evolution, and has done well, but as it moves to becoming internationally recognized as being a hub of ADR, is to raise the standards, and we've talked about this, to a level that has no challenge whatsoever. And because of the diversity from rural community-based ADR to court-annexed mediation, which I have experienced and seen in Kenya and other parts of Africa, ADR will have a very different meaning to different people. And that's okay to a certain extent. But what we will have is a generation coming tomorrow and the day after that will want to see standards harmonized to an extent. And I think we have to really help Africa think this through, and for those countries bold enough to be quite brave and recognize there can be different ADR for different people. But at all times, those standards stay at the highest level. The second challenge that I experienced in having done some work in Africa is the role of faith-based institutions, and particularly in this region here in the Middle East and in India. Faith, people's faith, personal faith, plays a big role in the ethics and the values in which they want to operate to resolve the disputes. And Africa should not be afraid of looking at faith as an advantage and not a disadvantage. Because it is this region, for example, and Mr. Mohammed has spoken about this region, its history, the faith of Islam, which came here 1500 years ago, which has been quite pivotal in helping the community here, the people here, to say, in the event of a dispute, you should seek assistance of your peers and elders and religious leaders. And for those of you that have done training with me, I always talk about this idea that faith leaders are great mediators because they always start with a level of trust. You share values, you share a system of understanding. And Africa is such a plurality of this notion that it has a huge advantage with its people and around the world to bring those people together. And I'm not saying we should only be that, but it has a great opportunity. And maybe I stopped speaking now.
Well, thank you very much. And what would be according to you the main advantage of going to Africa, especially to make African parties and clients and people use more African institutions, for instance?
I mean, you come from Mauritius.
I was the head of the institution there.
Who doesn't want to go to Mauritius and have an arbitration for a few days? So I think landscape and geography. And I think the other thing I wanted to share, and we have many people here in the room from Africa as well. Africa has an incredibly talented people and a young community. I think the average age of Africa is 19. 19. You have an incredible opportunity if you get it right, that you provide amazing ways of thinking. And this idea of having tools in the toolbox to resolve disputes for yourselves and for your peers helps a continent grow without the baggage of litigation. So that's the big advantage.
Thank you very much. Lady Koome, is there anything you would like to share with us before we open the floor to the audience?
Okay, just enjoying listening to Shamji's analysis of Africa, and what is most poignant is how we can leverage on the faith-based organizations. In fact, the work we are doing in Kenya, we are partnering with the faith-based organizations, and one of them has set up a center for dispute resolution within their communities. Actually, like the Muslims, the Aga Khan, they already have a very established system of resolving dispute. Now I'm talking about the Christians who set up a huge center in a big county, a big city called Nakuru, which I launched recently. So actually, Africa is the repository of knowledge in terms of dispute resolution, so that even when we come to building standards, I also want to share with the participants that the Chief Justices of Africa have come together to promote NDR and all its facets in our various institutions. And we have signed a memorandum of understanding and even appointed one of us, the Chief Justice of Uganda, to be the first promoter of that initiative. We had a meeting in Kampala, where all the Chief Justices of Africa converged. And sometime, I think in May, I am going to host the second summit of NDR of the Africa Chief Justices, because we want to use the judiciaries to propagate the knowledge, to create the systems, to create the standards, and then working with the judiciaries, it becomes very easy. And I'm hoping the International Hub for Dispute Resolution for Africa can also be established in Nairobi. And I'm ready also to champion that as the Chief Justice of Kenya.
Excellent, that's fantastic. So now we'll open the floor to you, Yannis, if you have a question, it's now the moment. Yes, please. Would you like to answer one?
So, one question.
Thank you very much, lady, and also to the panelists in a fascinating discussion. I have to enter a school note because my home jurisdiction, Tony guys with dispute filing, we support ADR, ODR's mediations. My home jurisdiction is England and Wales, where we have barely begun to integrate. I like the word integrate ADR. I like the words institutionalise ADR with things. But in England and Wales, we've barely begun to integrate ADR into our common law system. And so my question for the panel, for the lady, is this: is the ultimate, we have a backlog of probably 520,000 cases, civil cases, falling. So my question is this: is the ultimate backlog buster mandatory mediation in pre-contract? Pre-court, is that the solution? Thank you.
Thank you.
Is there anyone from the panel would like to answer this question?
But I can speak out loud. That's fine.
Use that microphone.
Yeah, I guess everybody can hear. Well, I guess, see, the UAE has adopted something similar to that, where you do have mandatory mediation through court. And they started with the family cases, but not the inheritance cases, as Rahim mentioned, but it's the family divorce related cases where you go through a mandatory mediation to start with. With the common civil cases, the UAE has adopted a what is referred to as a reconciliation committee. The problem with that is the parties use it as a procedural step to jump to court. And I think, in the future, we will see that there will be further adoption of trying to resolve the cases there and trying to mediate it at that stage. But I think it is a critical element, and it goes back to the backlog because the UAE suffered a lot of that, and as a smaller jurisdiction with a lot of transactions going on through the UAE, the court system had to kind of deal with the amount of work that was coming its way. So it has its pros and cons. They have put other pressures like timelines to resolve cases with judges also. So you do see things being rushed sometimes, which is unfortunate. But things do have their pros and cons. But I think from a generic point of view, it does help a lot, and it does help with resolving cases at start. And we do see much faster judicial system here. A court of first instance judgment would take you about 3 to 6 months tops. Another 6 months for court of appeal. You hit your final cassation judgment by 2.5 years to 3 years. And this is a lengthy case. You can have it completely resolved within 1 year if it was quite quick.
It's true. And to what Mohammed said, and particularly from the jurisdiction which I can claim to be the hub of backlog, which is India. And not 2.5 years. 2.5 years is not even the court of first instance at our jurisdictions. So, but what we have got now in the commercial disputes is a mandatory pre-institution mediation. You can't even institute a case on the commercial side if you have not had a session of mediation, and it is not being used as a tool for this procedure. It is a very effective deterrence now because there is a lot of resolution that happens just at that mediation level, because your war has begun with this paper and notices and that ego has set in. But if you meet in one room, you probably just resolve.
Excellent. Thank you so much for sharing this with us. We have a second question.
Microphone already.
Oh, okay. The next one is yours.
Thank you very much. I really want to say thank you to the panel. It's a very, very different discussion from what we've had the arbitration week and a unique one. So I have a question on the practicality of a lot of what you said. So we've had a lot about alternative justice systems and so on. Now, in the context of a construction project or a big infrastructure project, and in the context of communities around that vicinity where the ideal of party autonomy is integrated in a very different way, do you have examples of where these ADR alternative justice systems have come in quite handy in resolving a dispute that has environmental issues, public participation issues, and so forth. So thank you very much. And yeah, Kenneth Wayne Kima from Seattle, Kenya. So very, very pleased to see our patron speaking in this forum. Thank you.
Thank you so much for your question. You raise a very, very important question. It's a long answer, but I'm going to keep it really, really short because there are many examples I can give you. You will know that ADR International is in 45 countries. One of those countries is Bolivia. Bolivia has the largest reserve of lithium ion in the world, second largest in the world. And its biggest challenge right now is the mining of that iron, which is critical to the infrastructure of electric cars and mobile phones, etc., and communities that are living around those mines and areas where environmental, community impact studies are simply being overlooked. I mean, I'm not telling you anything that's not out there. But we have one of our representatives in Bolivia, Fernando, who's been sharing with us how we have been able to use negotiation, dialogue, facilitated dialogue, to try to create a deeper understanding of that impact so that those that want to go in the commercial way and those communities that already live can try to create a dialogue of understanding. And if you remember, if you think about these, this land where this reserve is, it's not developed anywhere. But it is a community that has been there for thousands of years. And trying to have that dialogue is difficult. And the examples that we have given them, and Zoe and I used to be part of a forum called the UIA, the Union of International Advocates. And in that forum a few years ago, we were taught about how Holland had a similar problem with bridges and the waterways and how communities had a huge problem. And this dialogue and consultation reduced the planning time from 10 years to 2 years, brings the community back on in a way that allows them a voice through it. Many NGOs already within Africa and Asia are using these same principles. So this already exists. This is a classic form of ADR, not for a resolution to a dispute, but creating a dialogue. And I talked about another example, the last one I'll give you before we move on. The Nile River has the biggest potential conflict in the world. Every country that borders the Nile wants access to that water. And it starts in Uganda and ends up in Egypt. And all along the way, everybody wants some water. And 40 years ago, the UN created a mediation meeting system once a quarter, where these people would come together to discuss the challenges of the last quarter and potentially what would happen in the next 2 quarters. This allows that dialogue facilitated to get to a place where you allow community voice and participation. So a very short answer, we could talk for longer on that. I know we're running.
Thank you. Yes, we are unfortunately running a bit out of time. We've got like 2 last questions. I think the lady up there, and the last question will be for the lady in the front.
Thank you so much for the great discussion and the great panel. It was really enlightening and very informative. My name is Mariam Kaldas. I'm the Executive Director of the Egyptian Center for Arbitration and settlement of non-banking financial disputes. It's a newly established center in Egypt by presidential decree, independent center, and it specializes in non-banking financial disputes. I really like when you said that it is very important to give more importance to training and to raise awareness on arbitration, and also to include judges, because without the judges, by the way, I was working at the Ministry of Justice before joining the center, and the judges have a very important role. But my question is, if we really want that Africa, to have Africa as a hub for ADR, how can we encourage arbitration centers for arbitral institutes to cooperate rather than compete, to create a culture of arbitration? So this is like, I need to know how can we cooperate rather than compete?
I'll take that.
I can't answer this one.
Thank you so much for that question. Look, the nature of arbitral institutions is to be successful by bringing the most work, okay? But if you look at someone like Singapore, which, 15 years ago, we were going there for anything but ADR. But what Singapore has done is, by creating an ecosystem, you've got SIAC and you've got SIMC and all these other places coming up together, they have created an opportunity which they do collaborate on. They are competitive, but collaborative in competition. And so what has happened is, no one is saying go to one institution, they're saying go to Singapore. Right? We don't talk about, but when you talk about London, you think of LCIA. You think of Paris, you think of ICC. So how do we change that narrative? And this, Her Honor, Honorable Chief Justice talked about this idea of Chief Justices really working together so that from the top down and the bottom up, this changes. So what we're doing in Egypt is incredible. What's happening here in Uganda and Kenya and other places is amazing. And it needs to happen through a lot of dialogue now. Otherwise, we'll end up with one or two hubs. And Dipna will talk about this idea that what Mauritius did, 2 arbitral institutions, and they had their challenges, but it's still difficult because it's not seen as Africa, it's seen as Mauritius. And we need to start thinking about how we change that as well. But short answer again, sorry.
Thank you. We can have a long debate about the 2 institutions coexisting in such a small country, which is Mauritius. We'll have that afterwards. Let's move to the next question and the last one.
Good evening. Thank you very much for an excellent presentation. I'm not sure whether your leadership is still with us. My name is Mohammed. I'm from Kenya. My question is particularly to the Madam CJ.
Yeah.
Madam CJ, rest assured that you have great delegation representing Kenya here in the room. So thank you very much. Your leadership, you mentioned that ADR is a quicker method than litigation. And when investors are coming to any particular country, when they're looking at the seat, they look at the role of the courts when it comes to setting aside an enforcement of arbitral awards. Now, I'm a practitioner. I do both litigation and ADR arbitration. The challenge then comes, the arbitration aspect has run smoothly a year, 1.5 years. But then when it comes to the court process, it takes a longer period. What policies are you putting in place, or what actions are being taken by the courts to reduce this period so that we are saying ADR is an alternative to litigation? Otherwise, it's as good as litigation, my lady. Thank you very much.
Yeah, can I answer that? Thank you very much for that question, and my absolute delight to know that Kenyans are well represented in this great gathering. Well done for flying our flag very high in Dubai. You are right that What we need a lot is training so that our judges can understand that the reason why parties opted for ADR is so that their matter can be expedited and dealt with quickly. And therefore, when an award is challenged in court, that matter is given priority. That is what we are trying to do within the commercial division to sensitize the judges to designate, one or two judges who can fast track matters of arbitration so that they do not have to linger a lot in court. And I think we have really established the basis upon which an award can be challenged. Some people who do not want to pay when an award is against them, they would like to delay the matter by buying more time to challenge the award on flimsy reasons. But I think the standards have been set by the Supreme Court on how you can set aside an arbitral award, and then the finality of it in the High Court, unless, those other parameters which have been identified, matters of grave injustice and, have been identified in the arbitral award. That's when you can go to the Court of Appeal, a very small window, which many cases are falling by the wayside. So I cannot agree more that more and more training and sensitization of our judges about the essence of ADR is absolutely necessary, because I think we've just managed to do much at the commercial division, and we have a lot more to do in the other courts around the country. Thank you. I hope I've answered the question.
Thank you very much, Your Leadership. We will now end the session, and I will ask Your Leadership to stay with us for 5 more minutes so we can have a group picture. But before we end the session, I'll invite Zoe to quickly share the closing remarks with us.
Thank you so much. Thank you. Thank you so much, ladies and gentlemen. I have the pleasure to close this session on Africa as a hub of ADR. First of all, our sincere and special thanks to Honorable Chief Justice of Kenya, Martha Koome. Thank you so much for sharing your time, and despite not being able to travel to Dubai, you have really found your words very enlightening. It is clear that Africa has a huge opportunity to become a major hub for ADR, and it's also clear that there are some important structural changes that need to be made. At AOI and EICR, guiding light has been to be global but local, and this principle resonates with you, having what you said with us today. To our other fellow speakers, Mr. Mohammed and Kunal, once again, their contributions were very succinct and enlightening, and their experiences of the India and the Middle East have given us all much for thought as we help develop new hubs across Africa. Unfortunately, Mr. Kunal had to leave to catch a flight, and Mohammed is hosting the reception. That's why we're there, so I'm so sorry. And a big thank you to the audience in the room and online for listening to us, and we're looking forward to more interesting conversations about ADR and ODR. A special thank you to Gordon Orgola.
Couldn't stand up.
Our Kenya who have been instrumental in organizing this event today. Thank you so much, Gordon. And before we let you all go, we wanted to remind you about 2 events that we are hosting. The godfather of online dispute resolution, Mr. Colin Rule, is arriving tonight from the US, and will be conducting a masterclass on ODR tomorrow afternoon from 2 to 5. And another session called arbitration on Thursday at 4 to 5 p.m. as part of Dubai Arbitration Week. And our colleagues Katie and Ruki are available to take your names if you would like to attend. And of course, last but not least, a huge thank you to our team, to the DIFC Academy, for hosting and organizing the event, and wishing you all a wonderful evening. Thank you so much.
Thank you so much, everybody. And just to say that Dipna is going to be the managing partner of AOI Law. And so, Dipna, good luck. Huge congratulations. Thank you so much. Thank you, everybody, so much. And we've got a quick photograph with you, Lady Chief Justice. Just a second.
Okay, let me clear my.
From that angle, we can have yes, I think two, one with the Chief Justice and one with the full group.
Yeah, yeah. Let's, yeah, I'll be shaking. Yeah, you want to go and stand next to it. So we come inside a little bit.